Hi, I'm Locke Meredith with Legal Lines, and we're very pleased on the next show we're going to have Doug Morrow. Doug is the district attorney for the 19th Judicial District, which is East Baton Rouge Parish. He's also been a district judge in the 19th JDC for 12 years. We're going to talk about those particular positions he's had, his duties and responsibilities. Also, as you may or may not know, he's the announcer for LSU football. And we're also going to talk about the serial killer case and where they are in the prosecution of that case and kind of the system of prosecuting a killer. So join us on the next Legal Lines. Welcome to Legal Lines. I'm Locke Meredith, and I'm very pleased to have on the show today Doug Morrow. He is the district attorney for the 19th Judicial District Court. He's actually been a judge in the 19th Judicial District Court, been a pro football player, done a little bit of everything. Judge, I call you Judge because that's how I'm used to talking to you. How you doing?
Doing fine, Locke. Thanks,
Thank you.
And thanks for the invitation.
Well, thank you for being on the show. Give me a little personal history about yourself.
Well, I'm old, so I mean, it's going to take a long time. It's only a half-hour show.
Quick summary then.
Well, I was born in Thibodeau, but I moved to Baton Rouge when I was very young. Had a big family. I had 9 brothers and sisters together in our family, and my dad was a track coach at LSU and a horticulturist. So we grew up right off the LSU campus. We all walked to University High School, graduated from there, went to LSU undergraduate school, was fortunate enough to have a chance to play sports at LSU, and then played professional football with the Miami Dolphins for 4 years.
And I told you I did not know that.
Well, I'm one of the reasons, that they went to the Super Bowl, because as soon as I left the team to go to law school, they became successful. It tells you about my influence.
What did you play?
I was, back in those days, people played positions, and also the kickers. When I was in college, I was a place kicker and also with a pass receiver. In the pros, I did both. But that was just at the beginning of the soccer kickers when specialty started coming in the kicking game. So I was kind of at the tail end of the first wave of old guys. And
are you still announcing? I know I hear your voice regularly during the games.
I do. When I came back and started law school in 1970, I got involved. They were looking for somebody to broadcast freshman games at LSU, and in about 71 or 2, I started doing freshman games, and then 74, I believe, started doing the varsity games, the color on the varsity games, and I've been doing that since that time.
Now, what does that mean, the color?
Well, the analyst between play on the radio broadcast. I did some television in the mid-'80s when Tiger Vision started. Periodically, we'd televise a game, and I worked on those broadcast, but I enjoy the radio much more because the challenge is different. You have to try to describe in words for people that are listening exactly what happened. So it's been an awful lot of fun, and I've had a chance to see the ups and downs of LSU athletics and kind of stay close to the university, which has been a big part of my life.
How are they looking to you right now?
Well, so far they're good. Coach Saban's done a fantastic job recruiting and setting the standards high at LSU. And I think potentially if he continues to be successful from a health standpoint, can have a tremendous team this year. Next year it might even be better, but this year he's got great chemistry, he's got good leadership, he has a quarterback that has started to play extremely well, a lot of good young guys that can do all kinds of things well, great receivers, running backs, good defensive backs. So he has all the ingredients.
Time will tell.
And, and he's an exceptional coach, and he's got a fine staff. So, but the other guys show up on Saturday trying to beat you, too. Right. So it's real competitive out
Sometimes
there.
Successful, huh? Let's get into the professional part.
Okay.
You practiced for how long as an attorney?
When I graduated from law school in the fall of 1973 and went into practice with Tommy Benton's law firm, the Benton Law Firm was the name of it, and also applied for a job in the DA's office as an assistant DA. About 6 months later or so, one did come open, and I took that job and worked as an assistant DA for about 5 years. An opening came up for city court judgeship. By then, I had figured out I kind of like being in the courtroom. Litigation, as you know, is fun.
Yeah.
And it's really a real challenge. It's a test, very competitive like athletics. And so I decided those guys that are judges, they get to come in here every day, and it looks like it would be an enjoyable way to practice law. So I ran for city court judgeship, was elected. About a year and a half later, ran for district court, and then served as a judge until 1990 when I ran for district attorney.
So a district judge for how long?
District judge for just short of 12 years. city court judge for a little bit over 1 year. So a total of about 13.
In city court, what kind of cases? As well, most folks may not know, but the amount at stake or in litigation is regulated. It's a lot less, and you're dealing with more minor stuff.
And it used to be much less back in those days. It used to be small dollar amounts in civil suits. So you dealt an awful lot with traffic cases, small claims where people represented themselves, evictions, civil cases up to around $5,000, but generally they were small claims where people represented themselves and the amounts were less than that, or they were seeking some other relief.
But you got your feet wet as a judge.
Oh, yeah. And of course, the rules of evidence and rules of procedure are the same. And then a variety of misdemeanors in criminal court. DWIs, simple batteries, thefts, shopliftings. So it was a great experience, and a lot of it at one time. It was a good way to get started, and city court's a very important court.
I remember Johnny DeGravels went in ad hoc for a little while,
Right.
and he came out saying, I'm glad I'm out.
It'll wear you out.
Fast pace, isn't it?
Its volume is tremendous.
Now you went into the district court. How did it change?
Well, district court is, from a criminal standpoint, the way our court's divided, by rule, there are certain divisions that handle criminal dockets, certain that handle civil dockets. Normally, back in those days, we had some more experienced judges, and they normally would gravitate to the civil docket when they had enough seniority on the court. So the new guys that came in were always given a criminal docket, which was fine with me because that's where I had done most of my litigation. Started out in the criminal division in 1979, and Judge Lear is the one who had left to go to the Court of Appeal. I took over his docket and stayed in there till about 1985, and you handle anything from first-degree murders, aggravated rapes, armed robberies, kidnappings, all the way down to traffic cases. It is the entire spectrum of all criminal law violations. And district attorney's office prosecutes in there, so some of the people that I had worked with when I was in the DA's office, in fact, practiced in my court, as well as some of the defense lawyers that I knew well.
And then you moved to the civil.
And then when there was an opening in the civil bench, because I have a lot of interest in areas of civil law, actually more so than criminal law in many respects. Civil law is so vast, as you know, everybody's got to kind of specialize.
You really do. It's impossible to know everything.
Absolutely. And it's a wonderful education for a judge. You know, there's a tendency when you're up there and, you know, everybody stands up when you come in the courtroom, there's a tendency to think you really know a lot. But if you keep your mouth shut and don't demonstrate to them that you don't know very much, lawyers come in there well prepared, they'll teach you every day. It's the greatest education in the world if you just sit and let them teach you.
Because you hear everything.
Because you hear everything. And they're well prepared. And that was the greatest educational process I had, I think, being in civil court. Enjoyed that tremendously. I had intended to stay there for 6 more years and then run for district attorney. But circumstances were such that there came an opening in the district attorney's office for the term that would begin in 1991. And I thought about it, didn't want to pass the opportunity to do something that I intended to do all those 6 years later. So I made the decision that I better go ahead and run at that time. And so I did run in 1990 and was elected. Ironically, the day that I resigned, because when you're a judge and you run for a non-judge office, you can't keep your office, you got to quit. So that's, you talk about having young kids and the uncertainty of maybe not having a job in the future. The day that I resigned, the legislature gave judges their first pay raise in 11 years. So
oh, no.
What I'd
like to do on the next segment, let's talk about how the judiciary has changed and then your stint as the DA.
Great, sure.
Thanks for being with us. We'll be right back on Legal Lines. Welcome back to Legal Lines. I'm Locke Meredith, and again, very pleased to have on the show Doug Morrow. He's the district attorney for the 19th Judicial District and also formerly a judge in the 19th Judicial. Again, thanks for being with us.
Thank you, Locke.
We were talking about the judiciary and how you had acted as a judge. Tell me how, in your opinion, it has seemed to change over the years.
Locke, you know, and you as a person that litigates a lot of cases see this on a daily basis also. There have been a lot of personnel changes, and I think the respect for the judiciary probably that lawyers used to naturally have, as it has become more contentious and as there are more and more lawyers and it's become really competitive, much more of a business.
It really has.
Since lawyer advertising has come in, There's some lawyers that do it very, very tastefully, but there's some that are not quite so tasteful. And I think that's been somewhat destructive, frankly, to the legal profession, and something we really need to be alert for and try to improve. In fact, your show here does a lot towards, I think, professionalizing the profession, because it needs to be more of a profession than a business. And people perceive law as a business, and that's not good.
Nothing but money.
Yeah, and that fosters disrespect for the judicial branch. And frankly, my interest has always been in the judicial branch because it is the only truth-seeking branch of government. Most people don't ever think about that.
It's a good point.
But you have the executive branch, the legislative branch, both are political branches. And both of them are trying to sell their agendas to the public. The judicial branch is supposed to be a forum where you have fair rules, where things are litigated, and where the truth is supposed to win.
You hear both sides and you decide.
Absolutely. And that's good to have a branch of government that is reserved for that. As the competition increases, as professionalism decreases, there's a tendency for it to become more businesslike and less professional, and then the public loses confidence.
Well, it costs a fortune to run for anything these days.
Absolutely.
And it seems like it always boils down to money. How would you deal with that problem?
Well, I don't know that there is a good way to deal with it as long as you're going to have elections, because if you try to have government control of elections, I think you compound the problem.
Do you believe in, for example, I had Randy in here who was pushing before the legislature merit selection of judges. What is your thought on that?
Well, merit selection is a great idea if I'm the one that gets to do the selecting.
Right. Frankly, I was against it because I thought there's no accountability.
That's the problem. Because at some point, if we're going to have an elective system at all, or a system where somebody chooses at all, as long as you get to be the chooser, that's great. But if you're shut out of being the chooser, and in any merit-based system that I've seen, there's got to be a group of people or a person who's going to make the choice about who gets to be judges. That means everybody else doesn't get to have the choice. Ideally, I think that parish-wide or district-wide at-large divisions, the way they used to exist, is by far the best elective system that we could have.
And not the districts.
And not the districts. I don't think that that's been helpful at all. And I think the results, and I think everybody, all the judges even, will tell you that it's been destructive, and I think the litigants will tell you likewise. Now, there are some combination merit systems and elective systems where someone will be chosen by a committee, and they will be appointed and then confirmed either by the Senate or by some governing body, and then they run for re-election, but it's a yes or no re-election. It's approval, disapproval. Some of those systems theoretically might work well. In actual practice, my understanding is they haven't worked as well as anticipated. But the key to the entire thing is for good people to present themselves for office and for voters to become involved, as opposed to having 25–30% turnout. You really have to have people understand that it is their responsibility. You know, unique thing about the government in this country was and should be that it's owned by the people. But frankly, there are an awful lot of politicians in office that would like for you to believe that were it not for them, you wouldn't have any rights. And that's just not correct in this country. Just the opposite. Just the opposite. But people have to be reminded constantly it is their government.
We the people.
But there's a responsibility that goes along with it, and that's participation in the election process, involvement in demanding that government, in my view, should remain small. Government's way too big. It costs way too much money. It controls way too much of people's lives. That's very destructive to the responsibility, individual responsibility that this country is based upon, and it needs to be returned to that in order for this country to have a long-term future.
Let's talk about your duties and responsibilities as the district attorney. Kind of describe that to me. I'm not sure everybody really, you know, we see you on TV occasionally and see comments in the newspaper, and there have been some big cases lately that you're involved in. Describe the office to me.
It's an interesting challenge. The district attorney's office in Louisiana is a constitutional office, and it is created within the judiciary branch of the Louisiana Constitution. Many people think that there's a direct relationship between the Attorney General's office and the DA's office. In fact, there's not.
Or connection between the local government, Metro Council and the mayor and all of that.
Exactly.
Those are not your superiors.
No, not at all. The Attorney General in Louisiana is an executive branch office, and it is a statewide elected office.
In this case, that's Richard Ayoub.
Richard Ayoub is presently the Attorney General. The district attorneys are elected district-wide. The state's divided into judicial districts. East Baton Rouge Parish happens to be all of the 19 judicial districts. In some of the smaller areas or smaller parish areas, there will be 2 or 3 parishes that go to make up one judicial district. But there is a district attorney for each of those districts. And they're elected for 6-year terms.
And that defines your area of jurisdiction or power, in essence?
Venue, as much as anything. Interestingly, in East Baton Rouge Parish, because state government is located here, it turns out our jurisdiction is a little more broad than most places, because all of the things that go on in state government go on in our jurisdiction. So it is, for many purposes, we kind of have statewide jurisdiction. But venue in East Baton Rouge Parish is really the key to the cases that we handle in most situations.
Primarily, it's a criminal type of prosecution or involvement?
It is. We have the authority to represent the state of Louisiana both criminally and civilly, and we serve as the advisor to the grand jury. And all of those cases range, as when I was a judge, I mentioned first-degree murder down to traffic tickets, same thing. Every conceivable crime that might exist, all the white-collar crime, is the responsibility of the district attorney. And you determine who to prosecute, for what, and when you prosecute them. That's our obligation, is to evaluate all those cases.
Now, if you have interest in a particular case and the Attorney General has an interest in the case, who gets to litigate or prosecute?
It is our choice. It is
you
our
decide.
choice. Under Louisiana law, the Attorney General has no original criminal jurisdiction. If he is requested by a district attorney to come in and assist, he can do that. But he does not have the authority to come in and demand
and take it over.
Okay. There's always been a good working relationship, so it hadn't caused any problems. I think in the history of Louisiana, there have been 2 cases in which there was a conflict that had to be resolved by the courts, and so that's over a 200-year history.
How many folks you have work for you?
About 150.
And it's broken down into attorneys and support staff and such?
Yeah, we have 51 attorneys. And that will fluctuate 1 or 2 depending upon whether somebody leaves or in the hiring process, but generally right around 50 lawyers at any given time.
Okay. What I'd like to talk to you on the next segment about is the very high public cases that are taking place, the sniper case and the serial killer.
Good.
Thanks for being with us, and we'll be right back. Welcome back to Legal Lines. I'm Locke Meredith, and again, very pleased to have on the show Doug Moreau. He is the District Attorney for the 19th Judicial District. Again, Doug, thanks for being on the show.
Thanks, Locke.
Let's talk about these high-profile cases that you're dealing with now. We've got the serial killer case and the sniper case. First, let's talk about the serial killer case.
Okay.
Tell me where we are in that.
Well, where we are, Derek Todd Lee has been indicted, and he has been arraigned, entered a plea of not guilty. The trial date is scheduled presently for March the 1st. It is a capital case. And in capital cases, there are numerous pretrial motions. There are a lot of pretrial motions that are filed in capital cases that don't really exist, but lawyers file them anyway.
Make them up, huh?
And it's all just kind of part of the culture of a capital case, which is different than any other case.
Define for the folks what a capital case is.
A capital case is one in which the possibility of death as a penalty exists. In Louisiana law, there are very limited circumstances. First-degree murder is essentially it, where death is an option, and the trial itself is divided into 2 phases. The guilt phase, which is the first determination of whether the defendant's guilty.
Did he do it?
Did he do it? And if the jury finds a defendant guilty, and that's got to be a unanimous verdict, that same jury then hears another trial, which is the penalty phase, in which other evidence about whether or not the death penalty is the appropriate penalty or life imprisonment is. If the jury does not unanimously agree on the death penalty, automatically it's life imprisonment. So you can have an 11-to-1 vote in a capital case for the death penalty. In such a case, the defendant would receive life in prison.
What information does the jury receive when they contemplate the penalty? I assume the family gets to talk and express their concerns.
They do, and there's been quite a bit of jurisprudence in the last recent years. The Supreme Court of the United States decided a case called Payne versus Tennessee, where victim impact evidence was determined to be appropriate because the victims in these cases were not being represented whatsoever. As a matter of fact, there are many people still not aware, but there's a Victims' Rights Amendment in Louisiana that was added to our Constitution several years ago, and there have been statutes enacted That's in recognition of the fact that for so many years defendants were being given new rights that don't exist in the Constitution, but the courts were giving them protections that many victims were affected by. And so the victims at some point in time decided, look, we need to assert our rights, and they've done so. And that's proper because victims deserve to be represented, particularly in homicide cases where you have the victim by definition is not able to speak for himself. So his family members are tremendously affected. They've lost someone that can never be replaced. And it's been a good move to try to reestablish some balance in the criminal justice system. In a capital case, all these things come to bear on the same stage. It's a fascinating sociological event as much as a legal event because you have people that have varying agendas that become involved in them.
Well, we were talking about that. How many lawyers does this gentleman have?
Well, we were in court for a hearing the other day, and I counted among the various lawyers that were there representing his interest in one way or the other, a total of 8. 3 from the local indigent defender board, various contract lawyers, a prospective lawyer who was thinking about becoming involved in the case, an appellate lawyer, a person who was an expert witness who came to the hearing to testify.
Now, why are these guys interested in this case? What is their motivation?
Well, it's interesting that there are an awful lot of people, and they have a right to oppose the death penalty. I fully understand that. Under our system of laws, the death penalty does exist, and the way to abolish the death penalty is through the legislature, to have the legislature change it. Well, the polls show a vast majority of the people approve of the death penalty in the appropriate case. So that is what the law is in Louisiana. What many people have discovered is that if they become involved in the judicial process and attempt to either bankrupt it or to delay it so long that the victims' families become frustrated and just give up, that's their most effective way to battle it. And so you have a lot of lawyers that have these personal agendas that become involved as players in capital cases.
And when you say bankrupted, as I understand it, these guys are getting paid with public funds.
That's correct.
Explain that to me.
Well, we have an indigent defender system. It is created pursuant to not only federal constitutional law, but the Louisiana Constitution mandates it. We have a local indigent defender board that is funded with public money. We have state appropriated money for supplemental assistance. And the state board has entered into a number of contracts with various lawyers and law groups. It used to be these groups received funding from the federal government. And Congress reworked their budget several years ago, and they rewrote the federal habeas corpus laws. And in the course of doing that, they took away all of the funding for the anti-death penalty groups. But those same people still exist. And so they started looking for places where they could obtain funds, and they have turned to the state. So many of those people obtain funds from state-supported institutions, and they use that. If they used it to actually represent the criminal defendants, I think that would be wonderful, because that is appropriate. But I think it's misused by many of them in
pushing in an
personal agenda. Yeah,
right.
And that's one of my concerns in cases like this.
Who decides whether or not they get to represent the particular defendant?
Well, the court appoints attorneys to represent indigents. The local indigent defender board exists for the purpose of accepting the appointments. That's their obligation. That's what they get paid to do. They have contracts, though, with these other people. I mean, they can bring in other people who are willing to come in and assist. And it's like a lawyer who's assisting another lawyer in a case. The court can't really control that if that's what you want to do.
I understand.
So in the criminal context, that's the way it occurs.
Where do you see the case going next?
Well, we have some matters that are on appeal right now. I take it back. They're writ applications, discretionary review applications with the Louisiana Supreme Court that the defendant have made. They've filed a bunch of motions, many of which I think don't exist. They've been ruled against. They're seeking relief from the Supreme Court in Louisiana.
Judge, thank you so much for being on the show.
Well,
I know you're going to do a great job on that, and we look forward to having you back.
Thanks so much. Enjoyed being with you.
This is Legal Lines with Locke Meredith. Thank you for being with us.